Good morning. I guess we'll get started. I don't want to penalize all of you who actually got here on time. So welcome to this morning's panel on the AT&T Time Warner decision, what it means for technology and media mergers. As obviously you all know, a week ago, Judge Leon handed down his decision in the Justice Department's case against to block the AT&T Time Warner merger, the first federal court ruling on vertical mergers in 40 years, and also, as obviously you all know, his ruling allowed the merger to go through without any conditions. And the questions, or the range of questions we want to discuss this morning, is what this decision means for vertical merger antitrust enforcement generally going forward. Is it an outlier, as some people have suggested, or will it open the floodgates? And does it have implications for other types of mergers, like horizontal mergers? And also, what does it mean more generally for the development of distribution and content markets? As Judge Leon stated in the first sentence of his opinion, if there ever were an antitrust case where the parties had a dramatically different assessment of the current state of the relevant market and a fundamentally different vision of its future development, this is the one. We have a great group of experts here to discuss these issues. You have their bios, but I'll briefly introduce them. Tim Brennan is a professor of public policy and economics at the University of Maryland in Baltimore County and a senior fellow at the Resources for the Future. He was for many years previously an economist with the Antitrust Division at the Department of Justice, and also has been chief economist at the Federal Communications Commission. Bill Kovacic is a global competition professor of law and policy, professor of law and director of competition of the Competition Law Center at GW's School of Law. He held many high-level positions at the FTC, including and up to and including being chairman of the commission from during 2008 and 2009. Diana Moss has been president of the American Antitrust Institute since January of 2015. She's an economist, and she's developed and expanded AAI's advocacy channels and strategies, and strengthened communications strengthened communications with enforcers, Congress, other advocacy groups, and the media. And her work spans both antitrust and regulation issues. And Christopher Yu is the John Chestnut Professor of Law and Communication and Director of the Center for Technology, Innovation, and Competition at the University of Pennsylvania Law School. He has the distinction of a paper of his being mentioned in the first sentence of Judge Leon's opinion. So I'm going to dispense with opening remarks, and I'm going to just kind of try to get a conversation going. Hopefully, a little bit of diversity of viewpoints. I actually don't know what all these people think about this issue, and then I will open it up to the audience for questions too. I think I'm going to sit down for this. So my first question for the panel really is this the decision that you all expected? Maybe start at the end with Tim.
Decision I expected. I'll leave for later, I guess, whether it was a decision I liked or what ways or whatnot. I'm going to pass on the decision I expected simply because all I really knew about what was going on in the case was the press reports and such. I didn't sit around, I didn't attend the things, I didn't look at transcripts or whatever. So if I had any expectations at all, they weren't particularly well informed. I mean, I certainly had heard that, that Shapiro's testimony had not gone particularly well, which I suppose hinted at certain things. But in terms of just the empirical prediction or whatever, I'm just going to defer on that one simply because I didn't follow it carefully enough to, I think, really form one that would be sensible.
Bill?
I attended a number of events and had conversations with members of the DOJ Trial Team and some of their advisors, and it was apparent that they thought, as Tim had said, things did not go well, that they'd gone badly, and in a way that prosecutors, I think, seldom do. They were beginning to adjust expectations by saying, we're not going to prevail here. Now, judges, of course, can surprise. That's what makes litigation so exciting. But the division anticipated a setback and communicated that.
Diana?
Well, I'd like to know how the bookmakers did on the betting on the outcome of this case. I mean, I think there were three possibilities, you know, a full stop, a full pass, which is what we got, or something in the middle, which might have been, you know, some sort of conditions, most likely behavioral conditions on the deal. You know, I'm of the view that it ain't over till it's over. And you can sit in trials day in and day out and read between the lines and read the tea leaves and listen to the pundits, but when you get a judge like this and a decision like this, as we will discuss, you know, I think all bets are off. And I would have put my money on something in the middle, which was a pass with conditions.
With conditions, yeah. Christopher? Yeah.
Well, I guess I'll go out on a limb and say it is more or less the decision I expected in terms of its basic outlines, although its length and its tone might be a bit on the heavier side than I might have expected. I predicted before the case that I thought AT&T would prevail. So on the merits, you know, I guess I'm in writing saying that in advance. But more importantly, I mean, through the course of the trial, it became fairly clear that one of the themes for me taking from this opinion is sort of the growing importance of empirical analysis over theory. And I think one of the things that was very well reported and very conveyed by the trial was that Carl Shapiro's model was, the model was very sensitive to small changes in the assumptions. And it made it for a not very robust model, and that is a natural characteristic of many theory models. And I think many of us could have predicted that would have emerged as a major theme in the opinion, and it did. I think the thing that the major consideration that AT&T had on its side is the large number of vertical mergers we've had in the space recently, and that allowed Dennis Carlton to do very direct empirical assessments of what the welfare effects are. And based on that, the outlines of the opinion are largely what I would have expected in terms of the points that they emphasized, although, as I said, it is a somewhat longer and much more critical decision of Carl's testimony in particular than I might have expected.
So let me go the other way and ask the question that Tim was referring to is whether you think it was a good decision in both on the economics and the law.
On the law, for a district court judge, I think is absolutely the right decision because they don't really have the authority to overturn a great deal of law. They have to follow the precedents set by the Supreme Court and the DC Circuit. We all know the law over the last 50 years has become much more hospitable to vertical integration, backed by good economics, and as appropriately so. What I would say is that it is a fact-based decision, and the parts about it that I like is the discipline it played on certain issues. So for example, it's very easy for people to call things must-have programming. And that's often, as the opinion says, is usually thrown around as if it's just important programming. They actually analyzed, is this must-have programming? That is, would a competitor be harmed if they were denied access to it? And didn't just look for suppositions, look for actual record evidence. Because we have had a number of fights where people have been deprived of programming, particularly even some of the programming there are at issue in the case, and it didn't have those effects. And so what we see is an affirmation here of the law, which I would have expected, but the rigor of the analysis in terms of looking at what the actual theories of harm and looking for evidence tying directly to it, both in terms of that, and the other one that struck me is potential competition or potential harms. Potential harms are very easy to hypothesize. The real question is, was there actual evidence behind it? And I thought that was, I actually like those aspects of the decisions a great deal because it provides the discipline that antitrust analysis needs. Fact-based decision-making is always preferable.
So, yeah, Diana, and also, I mean, some of the critics of the decision, I think, that I've read, are putting forth the view that the judge didn't really understand the leveraging theory. So,
I think they, I disagree. I think he understood the leveraging theories, he just didn't find them convincing. So one of the things about the leveraging theory, you have to require several steps, which is you have to have the ability to leverage that has the market structure, has to be prone to it, and it requires very particular structure, very particular market structural conditions for that to happen. Second, even if they have the capability, they have to have the incentive to do so. It has to be profitable for them to do that. And third, there has to be no efficiencies. And the things that were very strong in the opinion is he said it wouldn't be profitable in many circumstances for the merged company to engage. There was no evidence that it would be profitable that the merged company would engage in that kind of conduct. And there were conceded efficiencies all along. And so once you put all that together, I think it's very consistent with a fact finding, the facts that found by the court. And I think what people are complaining about when they say he didn't understand the leverage theory is that they didn't like the way he found the facts that led to that leverage theory.
So I'll answer the question, what do we think of the decision? We think the decision is probably going to be very quickly cabined in its scope and its reach for a variety of reasons. It's obviously very fact-driven. In fact, it's so fact-driven in an effort to make it appeal-proof that the judge has essentially created a situation where it would be very, very difficult to review it, to withstand judicial review, because it is so subjectively fact-driven. And very uncharitable, obviously, towards the government, very charitable towards the defendants. But for a variety of reasons, I think looking forward, I think parties, regardless of whether you're a defendant or a plaintiff in a future vertical merger case, will not look to this decision for support for their own case for a bunch of different reasons. One is, it says virtually nothing of consequence about law and economics because it was constructed to be appeal-proof. It refutes the role and the importance of economic modeling. I mean, that could hurt a plaintiff or a defendant in future cases. It's focused on, as I said, a very specific fact pattern with sort of an enormous dose of subjective interpretation by the judge. And it doesn't even get past the burden shift part of merger analysis, where we know as practitioners and academicians that there is a lot of meat in the process of merger review. And to add to that, it's sort of riddled with all sorts of inconsistencies, errors, misunderstandings about antitrust. And we can go through that in greater detail because there is quite a list there of these types of what I'll call snaggles. So I think for those reasons, even proponents of lax enforcement and proponents of vigorous enforcement will not look to this decision in the future to rely upon. And even the judge says in the opinion, I think this is a quote, he suggests resisting the view that this decision be more broadly interpreted than the facts, the specific facts of this case. So the judge himself cabins off his decision. And I don't know whether to thank him for that or not, but there is, as I say, quite a list of problems that we've identified.
Obviously, this was a self-serving statement, but the Assistant Attorney General said something to the effect that basically he didn't think either the theory or the evidence was flawed and that a different judge could have ruled completely differently. Do you think that's true? Or?
Absolutely. Different case, different judge, different opinion. All DOJ has to do the next time around when they bring a case, which they will, and we strongly encourage them to continue to do, is to get past step one. They didn't get past step one in this particular case for the wrong reasons, for judicial misunderstandings, for errors, for inconsistencies in the judge's reasoning. So I think a different court, a different judge, different set of facts could have produced
not,
something very different.
Not the same set of facts. Right. Yeah. Right.
As Diana was saying, the judge tells us the temptation by some to view this decision as being something more than a resolution of this specific case should be resisted by one and all, exclamation point. Judge Leon liked exclamation points here.
Yes.
I think he has 5. District judges, by the way, say this at the end of their opinions all the time. They say, I'm just resolving this case. That's all we're talking about here. A couple of things that intrigue me when you have this kind of litigation event, as the judge mentions, there hasn't been a litigated decision in a vertical merger case in the federal courts since the late 70s. So this is a rare event to have the judge weigh in on this. There have been things that touch upon vertical matters, appellate opinions that deal with consent decree modification debates, vertical restraints cases, but nothing that gives us insight here. And what might the opinion have done differently? There's no discussion here about the anchors of Supreme Court jurisprudence from 1962 to 1972. Now, the government did not brief the case that way, nor did the parties invoke these, because if you'd simply drawn a line around merger jurisprudence circa 1972, which is the last time the Supreme Court talked about vertical cases in cases like Ford Autolite, the government wins. It probably wins. All the efficiency arguments just get written off. Go back and read the last page of Brown Shoe, 1962, where the court says, there are impressive efficiency arguments here, but we cannot forget Congress's admonition to value economic decentralization as an end in itself, and we willingly sacrifice the efficiency benefits in order to achieve a more egalitarian marketplace. That issue isn't discussed here. The Supreme Court has not decided a merger case since 1975 on substantive standards. Maybe selfishly, from an academic point of view, one is intrigued in how the Supreme Court, if it comes back on these issues, what's it going to have to say about what it did long ago? When the court disengaged by the early to mid-70s after General Dynamics Marine Bank Corporation, which is mentioned here for a tangential point, the court was giving signals that it was starting to rethink what it had done from 62 to 72. There were faint signs that it was backing off, and you have to look at the last decisions as being a tentative indication of that. But silent since. It's extraordinary to think that our national merger jurisprudence has not been addressed by the highest court, right around the corner here, in now almost 50 years. It's astonishing. So every time you have a rare event like this, you wonder, are the old litany of the saints figures going to be summoned back up and discussed? Mentioned here, but only for subsidiary tangential points. There's nothing in the opinion that takes on the question that is a matter of popular discussion now, of course, about whether merger policy went off the rails over the last 30 years or so because it ignored that dimension of this court's thinking. You wouldn't know it existed here. So in one sense, as a technical matter, what about the treatment of the law? It's teed up using a very significant set of departures that the courts of appeals have pursued, with Baker Hughes being the anchor for the analysis. A unanimous decision, David Sentel, Clarence Thomas, Ruth Ginsburg, two of whom have gotten promotions since they wrote that decision. But Baker Hughes is not the friend of the federal government in any way. So that frames the analysis. So in that sense, it's a very cautious decision. I walk away from it wondering. I'm convinced by what the judge did here. If there's going to be a fundamental realignment of merger law, it's going to have to come from Congress. The federal judges are not going to do that. They're not going to push the fence out dramatically. That's got to come from legislation, and this reinforces it. I echo Diana's comment that if you drew another judge on that court, could you have a different opinion here? that instead of walking through Carl's testimony very carefully, and why did he do that? I think he saw Carl as being very formidable here. So a line at a time, I'm going to refute every single thing he had to say. Talking about maybe the best forensic economic testifying witness in the United States today on these kinds of issues, with an extraordinary record of success. He is not charitable in talking about Carl's work, but he talks about it in exacting detail as a way of, I think, showing how serious he thought Carl's testimony was here, supported by other witnesses. I can easily imagine that if this is given to another judge, that the judge writes 170 pages, except he's saying, at the margin here, I found Dr. Shapiro to be persuasive on these theories. I realize that the evidence is debated, but I found the third-party witnesses on whole to be persuasive, and I found the documentary records that were summoned up from the files of the companies to indicate an anti-competitive purpose that I give credit to. So, in that sense, could you imagine this coming out differently in the eyes of another judge? I could. What intrigues me also always about reading his opinions is, what was it about the way that AT&T framed the case that caused them to see things in a way that emphasized the dynamic nature of the sector, the possibilities for change, and seeing that the transaction would have benign or beneficial effects?
Well, AT&T framed, I think AT&T framed the merger as basically all about data. Combining a distribution company that had access to customers and customer data with a content company, and therefore could compete with the Netflixes and the Amazons of the world. The government's case really didn't talk about it in those terms at all, I think.
I think it recognized that those forces were present, but the judgment reflected in the evidence they were presenting is that I believe the term they use, these are complementary features of the marketplace. These are not core competitive threats.
Right.
In the sense of the Michael Porter 5 forces diagram, these are interesting substitutes that are not yet directly threatening the business model that the merging parties are using here. But I do think a longer-lived effect of this is that if you are litigating a merger in the future, and you want to persuade the government to expand, or the court certainly, to expand the circle of competitive substitute products or services, this is a case that tells you expand the circle, include more products and services, give more effect to these dynamic possibilities where they're supported by evidence in the record. This is a nice case for parties that want to say that the incumbent products are important, but they don't represent where the market's going.
Do you want to move on to Tim, or can I just interject quickly? So I just want to add to something that Bill said. So I alluded to a snaggle of inconsistencies, errors, and misunderstandings. And certainly relevant market definition is on that list. And there are two major areas where there are these glaring inconsistencies in the opinion. One is on relevant market, and one is how the judge handles evidence from the plaintiffs versus the defendants, which is very, very different. Very different treatment given to the different parties. But on relevant market, to Bill's point, the relevant market wasn't contested. I mean, the defendants and the plaintiffs agreed on the relevant market to include MVPDs and virtual MVPDs. Was not an issue. Even the judge says this isn't an issue, but then spends probably a third of the opinion essentially implying why the relevant market is broader than what the parties have agreed to. And so he pontificates and expands on how, this is a quickly changing environment. He talks about the role of digital advertising and the pressure placed on the marketplace by the platforms, the tech platforms like Google and Facebook. He talks about the rise of the OVDs. He talks about cord cutting and skinny bundles and unbundling. I mean, he covers the ground to make a shadow case for why the relevant market is really not what has been agreed to in this case, but is far broader than that. And it was an interesting tactic, whether he was implicitly agreeing with the defendants and the case they teed up for why the market is much broader and the merger is thus inconsequential. But it bleeds over into very other important things, like buying into the arguments for the merger in the first place, which is, we have to merge to be able to compete in this dynamic, changing environment. And Netflix and Amazon are sort of organically, vertically integrated, and we got to compete against them. Never once asks the questions or questions the motivation for the merger. Why the parties could not get to their efficiencies or their benefits through good vertical contracting. Never questions the notion at all that if they did it on the merits, AT&T and Time Warner could perhaps get to the place where they were more competitive and could compete with these other participants in the market. So punchline is huge hard swerve on the relevant market issue. Accepted relevant market, but then went on for pages and pages essentially to dispute the relevant market and to indicate that he thought it was far broader.
There are lots of interesting things in the footnotes, especially some of the harder punches at the government's case. But there is a footnote in which, after identifying the rationale for looking at a wider collection of products and services, Netflix, Hulu, Amazon Prime, he does have a line where he says, "Of course, it's possible that the traditional model could be a submarket." He's hedged a bit. I think he recognizes that there's an important judgment being made here. But so there is some, as Diana was saying, there's some ambivalence, I think, in his mind about exactly what the relative frontiers for competition are here.
So let Tim talk, but also Diana basically said she thought the opinion was appeal-proof, which would suggest that they're not going to appeal it. Do people generally agree with that?
Do you want to
Let Tim talk first.
I'm not sure what I'm supposed to be answering to, but I'll go back to the original question. I guess.
Everything.
By the way, I do want to point out that the dance floor is open. A couple of things. This will emphasize, some of these things will emphasize what others have said. The first is that I think that viewpoints like the one that James Stewart wrote about in the New York Times a couple of days ago on the case, this is just, it's just Bork. I think that's completely wrong. If it were just Bork, this could have been a 12-page opinion, not a 172-page opinion. It wasn't that, per se vertical, pure vertical mergers must be good, therefore. It wasn't that at all. So those who want to, think that believe that, that think that those candidates should still be kind of like on the table potentially, I think that they still are. Nothing about this takes out. I agree with Diane on that. I also, maybe disagreeing a little bit. I didn't read the decision as tossing out the bargaining leverage theory as a theory. Although I'll say one little thing about that in a bit. I do think that it's the idea that facts matter, which gets in some ways, that facts matter. I'll come back to that in just a second. The one thing that I was sort of disappointed in, but I'll probably leave that to later, is what the standards should be in vertical merger cases. And there's been a lot of arguments about what those should be. I've participated in some of those debates for a very long time, and I was kind of hoping, I wrote a blog post or two on this beforehand, that the case might resolve that, and it really didn't, but I'll come back to that later. On whether this could have come out differently or whatever, I basically read this and thought that Judge Leon's, I took 4 reasons why he came out the way he did. Let me change the order from how I had them. One was the thorough decimating of the facts case as presented by Shapiro. And maybe my pal Bill here has a sidelight as Carl Shapiro's agent. I can't quite you know, that gee, it's going to come out differently. I mean, you certainly don't get that opinion, you don't get sense from the opinion, but again, I didn't read the transcripts. Maybe it looked a lot better than it did as portrayed.
I think it was a rough time in the courtroom. It was.
A second thing, as others have pointed out, is the market definition question, although I agree with Diane. I think I would put it somewhat different, was that the first third of the opinion, or however long it is about why the market doesn't look the way we thought it did a while ago because people want to get data and all that kind of stuff, that what Tom had asked about before. But then it seemed to not show up anyplace else. It wasn't really tied to the rest of the thing. It wasn't like, well, we don't have to worry about bargaining theory because these guys only have 5% of the relevant market, which is really advertising, or something along those lines. I mean, that's an extreme thing. I'm not saying one should have come out that way, but it wasn't like that part seemed to have a whole lot to do with the rest of it. A third point, and this may get to the theory part that Chris was talking about, this is the thing that sort of struck me, was this whole business about is it programmers so desperately want to be carried that the idea that they would credibly threaten to withhold their product to get better bargaining terms or something, that was in econ speak, that was not a credible threat. And that if that's not a credible, now I'm not sure that necessarily gets rid of the theory, because you still may say, well, vertical integration changes the threat point, and it could have some difference, but he seemed to go out of his way to throw that, to take that on. I simply don't know about the theory in general. The theory in this case is to know how much difference that particular point made, but he seemed to think it made a lot of difference, and Chris could perhaps elaborate on that if other people want to hear it. The main thing, those are three, I said I had four. The one thing that kind of struck me as a non-lawyer reading this was the extent, the attention of what may tend to inhibit competition means. You know, is it possible or is it likely? I confess I had never given that an enormous amount of thought. I kind of wondered on the way in this morning, you know, if an originalist was looking at what the common meaning of the term may tend to inhibit competition was in 1914, would they say, well, we really meant likely? Or would they have meant something else? I don't know. And that may have implications for horizontal mergers as well. I'll let the other four attorneys on this talk about it. But that was a discussion that, and you know, I'm not a lawyer. As an economist, I have an opinion perhaps as to what the law ought to look like. But there's, at least I think, a separable question as to what the law actually is on this. And the fact that he seemed to feel a need to go into this at some length, I thought that was striking. And I just found the substance of that particular discussion really interesting. Maybe it was old hat to everybody else here, but I was somewhat taken by that.
Diana was, but also I'd like to just see if people agree with Tim's point that he made a couple of minutes ago, that this opinion did nothing, that it left the bargaining leverage theory alive and well.
I won't say well.
I mean, a couple of things. You know, he doesn't dismiss bargaining theory. I think the real damage here on the bargaining theory issue is that, well, it's two things. He dismisses the government's evidence offered up to support the bargaining theory as of quote unquote marginal probative value, because he requires that dismisses the value of the testimony that supported the anecdotal evidence that supported the bargaining theory, the enhanced incentive. He just dismisses that outright. He says, you know, it's essentially worthless. I think that everyone should be concerned about that, because the role of anecdotal evidence in merger investigations is huge. When you go out into, the government goes out and subpoenas parties in the market and talks to suppliers and customers and rivals, yes, they have to distinguish between just complaining and a focus on self-interest versus harm to competition, yes. But this judge essentially dismisses the value of anecdotal evidence in a merger investigation. That should be of great concern to anybody, whether it's a plaintiff or whether it is a defendant.
Do you think, Diana, he brushed it aside because he thinks as a category, I don't care, or was he saying, I thought it was rebutted? That the defendants raised a number of questions about the soundness of it that I didn't credit
Okay,
it.
all right, so I would say both. I think he brushes it aside as a matter of principle because he just doesn't believe it. And it didn't fall into his subjective, fact-specific approach to this case. But I would also point out that on balance throughout the opinion, there is also a very stark contrast between a stingy, uncharitable treatment of plaintiff's evidence, including testimony, including data, the model, everything, versus a wholesale love fest embracement of the defendant's claims, ranging from efficiencies to executive statements about, oh well, that bargaining theory, we don't really think that's very valid. He essentially embraces that. I mean, it goes all the way down the list. I mean, you could not see a more stark contrast between the treatment of plaintiff's evidence and theories versus the defendants. So yeah, I think bargaining theory survives, but there's a huge hit taken to the important role of anecdotal evidence that supports that.
I have to disagree with Diana. I don't think that the judge discarded anecdotal evidence. In fact, the judge went to great lengths to cite anecdotal evidence by the plaintiff's side witnesses that contradicted Carl Shapiro's model. And so when I hear you say that he's discarding anecdotal evidence, I hear you saying he disregarded anecdotal evidence that favored your side of the case, the outcome you preferred. I think a fair reading of it, he does cite anecdotal evidence. I don't think this is the death of economic modeling. I think this is the death of non-robust economic modeling. One of the critiques of standard game theoretical models is they tend to be very sensitive to assumptions, and small changes cause big discontinuous changes in effects. That has always been a weakness of that style, and there are good economic models. They just tend to be fairly resilient to being kicked around a little bit with small deviations in parameters changing things around. So actually and in fact, to the extent to which we're denigrating modeling generally, you see this in the woof and wharf of all of merger doctrine. If you look at the merger guidelines, market definition is no longer the central part of our guidelines. We now have better evidence of effects. And so what I find characterizes this opinion is actually not looking at formal structure, conduct, performance measures of market definition and structure, which we all know have been in the decline. They're actually finding direct evidence of effects. That is, in the bargaining model, I do think bargaining models are alive, but the old bargaining models compared the merger to the old status quo and says, would the merger change anything? And what always struck me is without any belief that the previous equilibrium was good, you have no idea whether you're helping or not. Instead, what they're asking for is not whether it changes bargaining power, which is everything that happens economically changes bargaining power, and we can't equalize that. It says, what is the effect of this change of bargaining power? Would it exclude a competitor? And it really looked at that sort of evidence to try to figure it out. And we may disagree with it or not, but I agree, bargaining's not dead, but we're now holding it to a higher standard. Consistent with the overall thrust of antitrust law, what are the effects? And that's really the dominance of the effects analysis. To go back to a couple things that Bill said, I do agree that this didn't change much, and one of the great curiosities, one of the things when all of us who teach this, we have to explain to our students, these old 60s and 70s cases, even though they continue to be cited, you can't take them at face value. We all know that the antitrust law has changed, but it becomes a problem because if you're a district court judge, you can't overrule the Supreme Court. And so you sort of play along with it, and you have to cite them. And even though a lot of the reasoning is more consistent, as you point out, with the post-70s revolution and vertical doctrine, they have to go through all that, as will the sort of the DC Circuit, and pretending. Was it a chance to clean that all up? Not really. I think it would take a pretty courageous district court judge to do that. The other problem is, as you know, Bill, is that the big change that we've had, and the reason we don't have cases, is the merger guidelines, which is the merger guidelines now put a negotiation between, it takes away the incentive to litigate. It's a negotiation between the merging parties and the enforcement authorities. And they create some sort of settlement, or they abandon the merger because they can't afford to litigate it. And so consequently, it's an institutional change more than anything else that's sort of frozen Supreme Court doctrine in place. A couple closing thoughts. on whether we take the market definition as is, the government versus including the Netflixes of the world, the government did push that as a merger definition, although it didn't make the heart of their case. It is noted by a footnote in the opinion. Whether it's accepted, that's fine. But what's fascinating to me, and this is to go a bit about inside the opinion, is the MVPD market is declining. Cable subscriptions are declining, and none of us expect that to change. And I was, before I went to law school, I went to business school, and I did marketing. And one of the things they taught us in the old days is don't just look at market shares, look at the behavior of people at the point of market entry. That is, young people who are adopting habits, what are they doing? My children have not watched an MVPD in years. And if you look at that, the harbinger of what that means is there is a fundamental change going on here. And the risk of riling up things up, it reminds me of the objections to the Hollywood video blockbuster merger, which I think was backed up by the facts. I'm not objecting to it, but it was on the eve of the decline of the entire sector. And there was a world in which you look at that and say, you know what, they're rearranging deck chairs in the Titanic. If you tell our children that we used to have to drive to stores and check something out and be charged overages and get nailed if you didn't rewind the darn thing, I mean, they'll look at you like you're crazy. But it's really quite interesting to see how that goes. The last question, is this appeal proof? I will say the citation of my work told me that they were going to stick pretty close to the old laws just because it was a fairly conventional analysis. I think the court on the law, which is the only thing they could be reversed on, stuck very close to the cases, including Baker Hughes, which they're bound by in that circuit. And then the rest of it, having laid out a fairly conventional framework, is fact-bound. And courts on appeal are extremely unlikely to overturn a district court's finding of the facts on the sensible idea that they saw the actual testimony, the demeanor evidence of these, the different aspects. They don't often get overturned on court unless it's the standard of judgment as a matter of law, where no reasonable jury could have, a fact finder could have concluded that. And given the recitation of the evidence, I just don't see that's plausible.
Let's shift and talk a little bit more about the implications for other mergers and for also the state of how antitrust is treated. I mean, is this going to, well, the two most obvious cases that are in the press now are the potential Disney Fox or Comcast Fox mergers. Would you expect, given this, that either one of them, whichever one goes forward, will have minimal problems with the antitrust authorities?
I would say the opinion made considerable efforts to distance itself from the past Comcast case.
Well, I know it's
and it does that. Obviously, if the government had won, it would have made it much harder to do mergers. I mean, that just goes without saying. Second, I do think that it didn't address a lot of it directly, but there are things that I think that are important. The emphasis on empirical analysis, the emphasis, the effects-based approach to what is must-have programming to make sure that it actually does prevent someone from entering. It reminds me of the old essential facilities doctrine. Something's essential, yeah, it would make my life a lot easier if I had access to it, and we now know that's not essential. Essential means you would die without it. And that's sort of the standard that they're holding up, which I think in the vertical space actually changes the configurations of assets in important ways. And I do think that the whole notion of potential competition and really sharpening that actually I think is very helpful. The other thing I will say is the conventionalness of the market definition also I think helps the cases because it is a fairly familiar orthodox way and it didn't attempt, I'm really struck, for example, the last merger that was blocked by regulators in sort of the space was the AT&T T-Mobile merger. And they used an innovative market definition of business wireless, which had never been made before and never been defended in court. And if we had seen an opinion going in very different directions, it might have a lot more implications for the future. This was a fairly conventional analysis in that way, and looking at traditional video markets, perhaps not even fully taking into account the extent to which they've changed, although you see that going. But I do see that is being normalizing. This opinion much normalizes.
You say, because obviously it would have been different had the opinion gone the other way. But does the fact that this opinion exists as it does now make it easier to get those mergers through than if it didn't exist?
I think so, with one caveat. So I think it didn't break new ground on law, but that itself is the big news. It reaffirmed sort of the traditional ways of analyzing things by and large. Second, it did embrace an empirical approach that looked at effects, not just changes in bargaining power, but actually looking at the likely effects on the market, which is in line with conventional orthodoxy. What it does do is throws more emphasis on horizontal aspects. And so when you look at the proposed Fox transactions, whether it's Disney or Comcast, the conventional horizontal parts of that actually are not the programming properties, it's the studios. And what's quite striking is that's something we tend not to focus on because it's not very much in the news, and we haven't seen major studio cases in a long, long time. But put simply, Disney is a juggernaut. It's 35% market share. Fox is 2 at about 15. So the merger in that pure space, which we don't look at, would make a 50% competitor. I think it's Warner's 3, and then Universal is 4 at about 10, just under 10%. And so if you look at those transactions, we have to ask ourselves, we're creating a 50%, a 1-to-2 merger, which would create a 50% competitor in one space, is important. And the other proposed transaction would be a 1-to-4 merger, which would create a 25% competitor in the face of a market leader that's 35%, is, I think, is going to have a very big impact on how that case will be decided, because the standard thing, you look at SIC codes, you figure out who the competitive industries are, and you look for horizontal problems after this case. And that is the big sort of flying under the radar horizontal question in that merger, which really hasn't been discussed.
Tim, did you?
Yeah, just on that question, just first just to reiterate something, although I wasn't aware of some of the details Chris just mentioned. I mean, these are horizontal mergers. I mean, yeah, one of Comcast is part of it, but Comcast's pure vertical merger was dealt with, at 8 years ago, 9 years ago, whenever it was. So I viewed it as like, say ABC and Fox merging, NBC and Fox merging. Not being aware of the studio side of this. Now
I don't think the Fox TV are part of the.
Oh, okay.
They're
They're
part of
part
the
of the
merger,
transaction.
Okay. Well, as far as the horizontal stuff goes, the one thing that might be relevant is this whole market definition thing, which may even go to the studio part. I mean, does it in the same way that the recording studios have much power because people have GarageBand at home or Pro Tools at home? I mean, you'd be kind of surprised, that I'm just not sure about how that all plays out. But I'm not sure that a decision in a pure vertical merger would have much of an effect on that one way or other. Maybe the market definition will bleed over, and nobody seems to think that there was much that was new in this likely versus possible kind of discussion that was a big part of the thing. So if those things don't matter that much, then these will proceed as if this had never happened.
Do you think, when the Justice Department was reviewing this case, obviously, or reportedly, I guess, obviously, they were trying to get some sort of, the Assistant Attorney General, as a general approach, wants to back away from conduct remedies and more in favor of structural remedies. Obviously, the structural remedies that were proposed were pretty big ones, and the parties, the parties didn't want to agree to that. Do you think this will generally mean that they have to back off this approach of trying to stress structural versus conduct and kind of go back to the way it's been done in recent years, or as a general approach?
The adjustment in the past has been to recognize exceptions. That is, if you're adamant about insisting on structural solutions or nothing at all, you've put yourself in a position where you're going to be in court a lot, at least initially, to sustain that approach. I think you come to realize over time that that's going to be hard. So you recognize you have some flexibility to define what's a structural remedy. You have some flexibility to say this case is different. It becomes maybe a larger policy aspiration rather than a hard and fast principle. But it's if you were going to truly dig in and say structure only, and as a footnote, Structural remedies have their complications too, especially if you're going into the world of intellectual property, of licensing. You have hybrids that involve a mix of both. So the clarity between the categories, I think, is blurred in many instances. But to demand only structure in a fairly pure sense undertakes a significant commitment to go ahead, and one wonders generally, is that sustainable without the kinds of adjustments that I mentioned?
I think the question about what does this portend for future mergers and approaches all the way down to taking remedies, different types of remedies, is a really important one. You could argue that this would embolden additional vertical mergers. You could argue that it would potentially embolden horizontal mergers, because issues like relevant market were, I think, were higher profile in this case. Was not handled well, but nonetheless is a higher profile issue, as well as sort of efficiencies issues. Also not handled well, but definitely efficiencies in relevant markets are key issues in horizontal merger cases. So, that's a possibility. I think there's a good deal of caution to stay away from using the decision, to green light future transactions. And I think it's really three major flaws that would make anybody, defendant or plaintiff, very queasy about relying on this. And we've just up here for an hour, we've already sort of been engaged in a vigorous discussion about the facts of the case, which is exactly what the judge wants from the decision. That's the way he framed the decision. So yes, we're deeply embedded in the facts of the case. But let's rise up to a more 10,000-foot level and look at why that decision may not work for anybody in the future. And one is, it places an inordinate burden on the plaintiff, right, to make the case. And this goes to Tim's earlier point about whether you have to show certainty of outcome, anti-competitive effects, or show probability of anti-competitive effects. He says that right up front in the decision. And he says, it's probably somewhere in between. Okay, fine. But then turns around almost immediately and says, no, the government really has to show certainty of anti-competitive effects. It wasn't enough to show that bargaining leverage increased or was enhanced pre to post merger. They had to show it was must-have content. They had to show that prices would increase. They had to show, they had to essentially prove that anti-competitive effects would result. That is arguably an inordinate burden, and really, in my view, I'm not an attorney, I'm an economist, a shift from previous precedent. That's number one. Number two, and this is probably the most troubling of anything in the opinion, the judge doesn't buy into the common sense notion that the companies post-merger will have a joint profit maximizing incentive. He basically says that the companies will continue to operate as separate profit maximizing entities. That runs completely counter to economic theory, to the theory of rationality. I have never heard or read a judge disavow the notion that pre to post-merger you now have a change in the profit maximizing the objective function of the company. That is truly, truly troubling. And then finally, this is, I think, the third major prong of why this decision should not and cannot be used to forward, to greenlight future mergers. There is no mention, no discussion at all of market structures, upstream or downstream, right? I mean, we all know that vertical mergers do not eliminate head-to-head competitors, but they most certainly have horizontal effects in affected markets, upstream and downstream. So concentration in the upstream content market, concentration in the downstream distribution market, that's critical information. No mention of market shares, no mention of concentration in the opinion. That is the predicate for determining whether a vertical merger is likely to enhance the ability and the incentive to exercise market power. No discussion of that at all. So the next merger that comes along, like CVS Aetna, for example, which is a very different fact pattern, which would be much, much easier to make the case for why it is anti-competitive Whoever puts that case together should focus a lot on the structure of the upstream market and the downstream, the upstream PBM market and retail pharmacy market and the downstream health insurance market. That's a critical piece of the landscape of the table setting whenever you talk about vertical merger analysis. The opinion is devoid of any of that.
So what's fascinating to me is this an important decision? Whenever I see a big impact litigation coming on, I see one side of the case saying, this is the biggest decision in the world, everything turns on this. And then if it doesn't turn out that way, it's like, oh, it's not the end, the sun is still shining. There's a certain sense in which we're advocates up here, and we're observers, where you have ideas. On some level, we don't even matter. Frankly, even the judge that renders the opinion doesn't ultimately matter, because what you'll learn I teach my students in law school, the judge thinks they control the meaning of the case. It's actually later judges interpreting what it means. And so in some sense, only time will tell in terms of how this plays out. And I think that this is, it'll be very interesting. I mean, as Bill said, this is great stuff for scholars. I mean, we love churn, and that's how we learn. What I do take away from it is, in answer to your question, Tim, they flat out say, the judge says, the burden of proof is likelihood of substantial lessening of competition, straight out of the act. And the question, I hear people saying whether this is unreasonable burden or whether it's met is largely, just can be to some extent agreement or disagreement with the way the judge found those facts. What I do take issue with, or what I would disagree with, what we don't see is, we don't see a lot of market definition, a market structure analysis of that. But that's consistent with modern merger policy. What we look at and see is lack of an obsession with market definition of what's in out and an emphasis on effects. And bear in mind, this is what we're at. This is what I complain about European competition law. It's not effects driven. And in fact, they do these structural analyses that lead them to find what many of us think are harms when there's no harms. So what we have, and what may make this merger unique, is we had a series of vertical mergers in this space that gave a pretty good empirical record of what was going on. And when they talk about meeting the burden, in a sense, one side had empirical models parameterized, theoretical models parameterized with some empirics. The other side had evidence from 3 or 4 recent transactions and what its effect was on consumers. And when I put those pieces of evidence together, one interpretation of this, it's very consistent with the growing emphasis in US law, in the merger guidelines, in the way the economics think about it, and the improvement of empirical technique, to be frank. And our criticisms of the EU law, that in fact what we should do is look at real world data points, real world outcomes, where people have done exactly the strategies that are claimed that AT&T will do, and often with the same properties that AT&T had for Time Warner, and look at what those effects are. And holding it to a standard of really, did it exclude a competitor, as opposed to, okay, someone might have paid a slightly higher price, someone might have paid a slightly lower price. If we're going to equilibrate prices, then we're going to block everything, because every merger is going to change price for somebody, and someone's harmed that way. That's not, so what I interpret as Tim's question about the burden of proof, I think it's consistent, but lessening of competition means actually harming the competitive structure of the market, not that one company will end up being disadvantaged versus the other, which is what the less sophisticated, less effects-driven bargaining approach opens itself up to.
Can I just ask a question, though, just to push a little bit on that? Dennis offered up a lot of evidence of, essentially retrospective evidence. Did prices go up after previous vertical merger? I think the key question there, and I didn't see this vetted in the opinion, I'm sure these amazing lawyers on either side of me will respond accordingly, but did that evidence reflect mergers that enhanced market power? I mean, you can take a perfectly innocuous vertical merger, a social mixer, according to Bork, and right, you won't have any price effects because the upstream and the downstream markets were pretty well ventilated and competitive. So where is the evidence from previous mergers that did enhance market power? Like, I would like to see that distinction. I wasn't in the courtroom, I wasn't listening to the testimony, but I would like, as an economist, to know how that evidence parsed out between innocuous mergers versus mergers that actually enhanced market power. Maybe there was no merger in that data set that enhanced market power, so thus there were no price effects. I mean, that's a legitimate question.
Well, the great thing about those previous mergers, think about one involved one involved DirecTV, the other involved Time Warner. And so you actually have some pretty good, interesting data points. So what's interesting is, we think of AT&T as a big company. In the MVPD market, they're small. I mean, their legacy product isn't huge. DirecTV is a substantial competitor, but it's not one of the top ones. But analogize this, the effect of the MVPD combination of DirecTV with a programming property, serious one. The obvious one is the Fox acquisition of DirecTV. If we actually could look at that and the subsequent spin-off of DirecTV. So we actually have two events which we can study, looking how it effect it has on prices of combining the two, but also looking at what the competitive behavior is likely to be involving that distribution property. Also, we had the recent divestiture, Time Warner and Time Warner Cable, which was the second largest cable MVPD in the country, was an integrated property. And by the way, none of these have made, obviously they were all dissolved, so these were not considered successful by the companies, they're all abandoned. We actually have the chance to look at what the potential withholding of HBO and CNN and what so-called must-have programming would be. And we have the evidence ongoing of carriage disputes, which actually creates these nice experiments of what that does to subscribership as well. And so yes, I agree if we had, when you mentioned the potential CVS-Aetna merger, I don't think the economics of those previous cases have much to do with insurance and these sorts of distribution mergers. Here we actually have the advantage of former vertical mergers of retrospective evidence, admittedly, and that's always going to be the case, but of the exact kinds of strategies with the exact properties and no adverse effect on consumers. And in that case, the gold standard is, that evidence. Now, all things being equal, the finance people says past performance does not predict future results. It's all things being equal, and everything's never equal. And if we take that standard, then we can never look to anything in the past, because everything's always different. Everything's a new day. Can we control for that stuff? Can we analyze it in an intelligent way? In a context where the government bore the burden of proof of creating a prima facie case that this would have a negative effect on consumers, theoretical model, empirical evidence on the properties, I get it. People may not like it, but I get it.
One last, and then I'd like to open it up to the audience.
Yeah, three very quick points, and then actually attempting to answer Tom's question. Just a very quick point.
Why would you do that?
Yeah, I know. Just because I watch those Sunday morning shows and just never, I stop watching because I'm just totally annoyed that they never answer the questions asked. The first is just on Chris's thing. I don't recall the word likely being in the Clayton Act. Maybe it is someplace. I'll need to go look. I mean, I turned my phone off, but I can't Google it to find out what the text is. But I remember just as sort of was this weird may tend to inhibit competition phrase.
May be substantially to lessen competition.
Maybe substantial. Yeah, there you go. There's clarity for you. The second on the market definition thing, the thing that sort of struck me about the lack of connection that I mentioned before was that that after going on what the market really looks like, quote unquote, one then didn't use, maybe it wasn't in the record, I don't know, but one then didn't go ahead and say, because AT&T is so tiny in what we really think the market is, a bargaining model of the sort that the government is offering wouldn't apply. I mean, that just wasn't there, which I found just kind of odd. And I will say, kind of going on with the market definition thing that Diana mentioned, there were a couple things about it that I thought were sort of raised my eyebrows a bit. One was kind of getting to an old objection. I hate the phrase cutting the cord, because almost until you get 5G, nobody really cuts the cord. They may decide to watch Netflix over their broadband provider, whether it's AT&T and Verizon or Comcast or whomever. But
Do you feel better about shaving the cord?
Well, the point is I think he said that Netflix and Comcast were in the same market. And until Netflix gets a whole lot of wires, I don't really think so. Or Netflix and AT&T were in the same market. He said, or Hulu, or whatever. And I said, well, that's not quite right. They're not MVPDs in the same way. Although I'll say that there was one point where it said, and this reminded me of I was at the Antitrust Division back in the early 1980s when cable was arguably the only game in town as far as MVPD service goes. And they used to claim they didn't have any market power either. When I was at the Justice Department, we used to say that cable claims that if there's a bowling alley open after 10 p.m., they don't have any market power because of this viewer attention you know, we're competing with everything anybody can do ever, sort of thing. And there actually was one allusion to that in the opinion, and that sort of struck me.
To throw out one thought, Tim,
yeah.
the latest data I saw, it's about a year and a half old, I think, is 24% of American households rely exclusively on a mobile connection for their broadband.
Wow, that's impressive.
It is.
Yeah.
And the trends are going
Yeah,
that
no,
direction.
that's great, and given what I've been paying, I'm ready to join them. I just have to get a phone that's newer than a
BlackBerry.
4S, but it's a, seriously.
Do you have a flip phone?
No, I don't. But I had a BlackBerry flip phone, smartphone, and I loved it, and I wish it was still around.
Pry it from your cold dead hands.
And the other thing I was just say was that I'm not sure how certain the effects are with vertical integration or what makes them certain, as Diana alluded to, but hopefully maybe we'll come back to that. Now, to Tom's question, which is on this structural versus behavioral remedies.
Thank you for reminding me.
If Diane's going to go to 10,000, I'll go to 30,000. I'm just going to throw something out here, which is that I thought that the Assistant Attorney General's statement made a lot of sense, but I've always thought about that in the context of horizontal mergers, where you want something clean, and where the behavior alternative is essentially price regulation. With vertical, in some sense, it's the content, it's the conduct itself that is at issue. We're concerned with discriminatory access. We're concerned with exclusive dealing. Now, whether you think those are good or bad or whatever, leaving that aside for the moment, that's what it is you want to stop. So if they come together and say, gee, we get these efficiencies, but we're going to promise not to do these sort of things, that's kind of if you think those things are problematic, that's a hard thing to have walked away from. My initial view of the Assistant Attorney General making that statement and then bringing this case was kind of burning his bridges behind him. It's like, it's kind of like, we refuse to settle, therefore, and that's going to make us a more formidable litigant. It happened not to work out that way, which leads me to think that maybe that wasn't the strategy at all. But in any event, I'm going to start throwing out this idea that maybe there's a reason why there should be a bias towards structural remedies in horizontal cases, but maybe if you think there should be vertical cases, that the bias should go the other way. And that's my theory of the morning as to why that might be, but I'm not sure it holds up.
Tom, you did ask us a couple of questions I'd like to answer in order to complete the exam before we go ahead. We admonish students to answer the questions.
That's right.
But on Tim's point and about remedies, I think what lurks in the background is an anxiety about the quality of oversight, compliance, monitoring, and effectiveness of remedies. I think that's part of what you see in Macon Delrahim's statement. It's an implicit recognition that there are administrative challenges associated with the oversight of consents that are not subject to full, extensive examination. And if you look at them carefully and ask, how do these things work, you have a lot of anxiety about that. And that's one reason to prefer what is portrayed as being a clean solution. Tom's question about the likely success of an appeal, I don't think the judge did things that were deviations from established legal principles here. I mean, on the question of the standard, three basic points in the spectrum: certainty, possibility, probability.
Yeah.
Nobody insists on certainty, and I don't think the judge is insisting on certainty here. He's saying it is. I need a probability. I don't need a mere possibility, but that standard is so easily manipulated that you ask yourself, what does it mean? So I can, with a few sleight of hand evidentiary tricks and findings, I can say, of course I'm requiring a probability, but you didn't show it to me. And I'm not demanding a certainty, but unless you specify in some detail what those concepts mean in practice, you can get any answer you want. But I think he did not say here in a line of type, which could be reversible, I demand certainty with respect to competitive effects. If he said that, then the DC Circuit might want to come back on this. So I don't see him treading across doctrinal lines that would have caused problem. And on the facts, as Diane was saying before, this is a very cleverly written opinion to avoid reversal. You'll notice there are a number of places here where he cites the Whole Foods opinion of the DC Circuit, both the plurality result and individual opinions. He's doing that because he knows that in Whole Foods, the trial judge, who wrote a mere 100 pages, rejecting the FTC's case, made a serious blunder. He ignored entirely the FTC's best arguments on the facts. He just drove past them. He didn't even have a page in which he said, I looked at the FTC's evidence, I looked at it, I thought about it, I just don't weigh it very heavily here because as the finder of fact, I'm entitled to make the judgments, and I did, and I get great deference for doing that. He didn't even have a page. He could have buried the FTC under a mountain of dirt. He didn't do it, so the FTC was able to come back. He cites Whole Foods here several places. The reason he's walking through what the government thought to be its best arguments is to say, I thought about it, I thought about it, I thought about it. You might not like my interpretation, but these are my views, and I get deference. So selfishly, do I like appeals? Yes, I like appeals because they generate appellate decisions that provide some clarity on these doctrinal points. But could the government overturn the decision? I doubt it. On lasting impact, let me mention two things, one of which the Department of Justice has suggested already. I think this will be a catalyst for new vertical merger guidelines, to come back on guidelines that have not been revised since 1984. The best if used date passed a long time ago. The expiry date, I think, passed a long time ago. But this could be the catalyst that moves the two agencies in the direction of new non-horizontal merger guidelines. One effect. And if we ask what impact in jurisprudence and decision making does this opinion have? Think of the district court merger decisions that really made a difference and why they made a difference. And if you think for yourselves, the single federal district court decision of the last 40 years that had the biggest impact because of the way it was spun by commentators, by the way the agencies enhanced it, I'd argue that's FTC versus Staples Office Depot, the first iteration in 1997, 1998. That had a big impact. It did something new. It at least openly accepted and although the judge didn't rely upon it, featured in the courtroom the use of econometric evidence, modeling, point of sale data electronically collected to bear out specific points. The recognition of a submarket within a much broader market of retail sales in question. I don't think this has that kind of impact, but for a judge who wants some confidence, a district judge who wants some confidence when looking at the old model and the new model, to say the new model counts for a lot, I'm going to credit it as being an influential part of the market. And on Diana's point, did Judge Leon did he assume that there'd be no change in the post-merger market? I see it a bit differently, Diana. I see him saying, whatever they try to do, they're going to be disciplined in a serious way by these other service providers so that they might change, but they're still going to have to run hard to compete against the following. So, but if you're a district judge and you want to point to an opinion that says you have an existing model, you have a model that seems in some way to contest it, and if you want to weigh heavily as a decision-making principle the emergence of the new alternative, this gives you a bit of confidence that you can do it and write an opinion in a certain way to make it work. And the last thing is, I think it points how hard it's going to be if the agencies want to bring the really edgy potential competition merger, which has been a policy prescription that's been given. How many commentators have you seen said Instagram, Facebook should have been challenged and blocked? Google DoubleClick should have blocked it. Google AdMob should have blocked it. You have the emerging, interesting, new, innovative firm that's swallowed up by a big firm. Stop it, because the smaller firm might have migrated in the direction of replicating that. I think this decision shows how you're going to have to collect a lot of evidence to show that it's more than something you thought might happen. You're going to have good evidence from inside the company's files that say, if I wasn't swallowed up, I think I could take these guys on in 5 years and overwhelm them. Or the acquirer saying, I've got to swallow them up because they are going to take me on and overwhelm me. This shows how a judge, prompted by the merging parties, are going to say, do you have more than a nice theory for this? And maybe you'll get a judge who's sympathetic, but you could get a judge who says, that's right, I want to see the evidence laid out. I mean, this again tells me how hard it's going to be, not impossible, but how hard it will be to expand the zone of enforcement to take on theories that have not had success in the courtroom in a long time.
You want to be very, I really do want to.
So briefly, the structural versus conduct remedies, I was just thinking, what are the biggest ones we know of in recent memory? AOL, Time Warner, again talking about Time Warner, the conduct remedy was access to instant messaging, which in retrospect seems like kind of a bad joke. Everyone thought it was the end of history. All it was the end of $200 billion of Time Warner shareholder value, and without exaggeration. And it's kind of funny.
They probably would have been pleased if the FTC had blocked it.
Absolutely.
Killed it.
And the people who hated that merger were the AOL people saying, why am I buying this old economy stock, when actually what Steve Case did is he exchanged funny money before anyone realized it for real assets. And so that's fascinating to me. I also think about the NBC Comcast merger, the conditions they immediately leap to my mind. Compliance with the Open Internet Order, which has since been invalidated, would make an interesting case study about whether in the aftermath, how costly that was and whether it actually yielded any real benefits in terms of the need to impose those restrictions. Hulu restrictions on voting, all these different things. I would say by and large, many of the stories that were painted about that merger, about how it hurt NBC News, NBC Sports and the like, actually it turns out that merger was the best thing that ever happened to NBC News. And has revitalized a property that in General Electric's hands was regarded as a cash cow and is now regarded as something that the companies can invest in, which I think is interesting. Standards is a tough likelihood, probability. There's a bunch of case law in addition to it. The only thing I'd caution is to make too much of those words, because they'll only bear so much. So I always think about this when we know in criminal conduct, it's you have to prove beyond a reasonable doubt, whereas in civil trials, it's the preponderance of the evidence. These aren't mathematical formula, and you're not going to be able to look at the facts and say, that would have clearly met this one versus that one, and whether we're talking about likelihood or probabilities and all these, you're never going to get that kind of definition out of them. They do create sort of moods the way fact finders bring to it. And so could you get under a different standard of a different judge? Yes. Do the standards of review make no difference whatsoever? No, they do make a difference. I mean, people do approach the problems differently, and I think they help that way. And it's just an interesting idea to ask too much of the words. I think is outside the scope.
Tom, can I say one thing on remedy, because I haven't gotten to chime in on that, and I did write the paper with John Cuoca on behavioral remedies, and there are good reasons to strongly disfavor behavioral remedies. They're regulatory in nature. They suck up resources for the enforcers and for courts. They don't change any incentives to exercise market power. All the bad behavior goes underground. Firms find workarounds. This is all well-established stuff. But I will note that in going back through the history of vertical mergers, about 25% of cases are cases in which a structural remedy was taken. And the rest are behavioral remedies. Okay, so to Bill's very earlier point, just because the government took a remedy and settled a case does not mean that the government, had they gone to court, would have failed. Now in this case they did. They did fail. They challenged and they failed. But in all those previous vertical merger cases that go back to the 70s, the government, had they gone to court, could possibly have won. There were signals that the parties themselves here recognized litigation risk. The defendants, they took a whole separate, requirement. So I mean that indicates that there was some risk. As far as what the Assistant Attorney General is doing, absolutely, this is part of a bigger plan to take the government out of the business of regulation and put it back into the business of law enforcement, right? Remedies need to have optimal deterrence value. Behavioral remedies do not have optimal deterrence value because they are easily circumvented. So, maybe we'll see more cases in vertical mergers where they go the settlement route. But structural remedies are very much on the table for a vertical merger, absolutely on the table. And they have been taken, as I said, in 25% of the cases. So, you know, I don't know that this is a loss for the government or boxes the government in on behavioral remedy policy. Because it's part of a bigger picture in terms of staying away from, you know, making antitrust about more about law enforcement, returning to first principles. But, you know, we'll have to see.
Okay, I'm going to open this up for questions. Hopefully there are questions. And we have a microphone, so wait for the microphone. We have 2 microphones. And also identify yourself and any affiliation. No questions?
People are just shy, Tom.
I don't know that this.
It's because it's a boring, uncontroversial topic.
Hi, Tom Struble from R Street Institute. So obviously with the benefit of hindsight now, we know that the district judge rejected the government's argument to block this case. I'm curious to hear from you all if you think the government brought the strongest case it could have against this merger, or if it had, you know, better arguments in your mind that you think might have been more successful in trying to block it.
I think operating within the confines of the jurisprudence, basically 1975 onward, I think they brought the strongest case they could, and I assume they collected the best evidence they had, and I do think Diana's right that the judge could have depicted it here as being a bit better than it was. Could have come to different judgments, but I think they did. What intrigues me is with whether, if they had wanted to win at all costs, whether you invoke the old litany of the saints. That is, you go back and you say, why are we here? We're here because we're concerned about undue concentration. We are worried, first and foremost, about assembling too much power in the hands of a specific media organization. We accept the brown shoe philosophy that economic decentralization for its own sake at the expense of efficiency is why we're here. And here is the recital of concerns in the 1950s legislative record for Seller-Kefauver that says that's so. That is to put all the older jurisprudence, call it dormant, and to press the courts to say, I'd just like a decisive ruling about whether this counts or not anymore, especially the 9 of you in the Supreme Court. You haven't talked about this since the mid-70s. That vocabulary has disappeared from the Supreme Court's jurisprudence. It used to be right in the center of the discussion, but it just vanished. The counterfactual case that would have intrigued me is, suppose that the government had said, nice arguments about your efficiencies, really interesting, but ultimately they don't count. And by the way, if you don't believe me, read Procter & Gamble, which says you can't overcome the anti-competitive effects probabilities with the efficiencies arguments. In other words, to bring the case that many of the commentators now say you should bring, you should wheel out all of the other arguments and say, let's test them. Let's test them in the bold way here. If you'd wanted to bring, in a sense, your most powerful case possible, that would have been the way you would have briefed it, argued it. And if the judge said, well, but what about these great arguments here about the benefits to the users here, and here, you'd say to the judge, read the last page of Brown Shoe. Just go back and read it again. Keep reading it until you understand what they're saying about the willing sacrifice of efficiency arguments for the sake of preserving a more egalitarian business environment, until the Supreme Court issues an opinion that says, lest there be any mistake, we don't believe that anymore. We don't think that's what the Seller-Kefauver Act was all about. You, the district judge, must follow that, notwithstanding all the subsequent jurisprudence that acted as though it wasn't there. I realize that is a case the government was not going to bring, but in terms of the modern debate about the purposes of merger policy and where merger policy should go, that's the case, the counterfactual that I would have found intriguing. That would have provoked a different kind of debate in the courtroom.
I'm not sure one would have needed to go there, but let me rephrase your question without necessarily answering it, which is one of the peculiarities here, to me, is that, let me put it this way. if you want to bring a vertical case, do you have to bring a bargaining leverage case, as opposed to just changing incentives to exclusive deal or a whole lot of other things which people may or may not think is bad? Somewhat separate argument. That this case apparently sort of hinged upon that theory is a theoretical matter and calculations based upon that particular thing. One wonders why. I mean, someone obviously felt that they had to go to that extreme to do that. Now, part of it is that bargaining theory is kind of hip in economics journals these days, and so maybe that's kind of the advice they've been getting. I'm not sure what really is going on there, but the way I ask myself the question you just asked is, did you really, if you thought there was a problem, was this really it? And I'm not saying that it was something necessary of this kind of this egalitarian thing or populist thing that Bill was talking about, but
Wasn't it
that just
really
seemed kind of odd.
Wasn't it really a raising rivals costs case?
Well, yeah, but they're different. You're asking the wrong person to defend that, but
You invented that theory, didn't you?
yes, something like that.
Yeah.
Had it been that, I think there have been some other interesting questions to ask. Maybe we can get to that later. But I don't. But just say that the way to do those is essentially just to argue simply that a price of something your competitors need is going to go up after this is over. You don't necessarily need to dress that up as this big bargaining thing. And that to me is whether there was a simple way to do that. Just to take an example of something I think was a relatively trivial theory here, was this business at the end about how they weren't going to let you use HBO to promote your MVPD. It's a little thing at the end. Nobody seems to think that was of enormous import, and I'm among those. But there's nothing about that was, well, you're bargaining, yada, yada, all this. It's just going to be, we're not going to let you do it. Now, whether that was empirically valid or theoretically sensible or not, one can argue about that. But that wasn't a whole lot of bargaining. There wasn't a whole big theoretical superstructure on that. It was just that. So I mean, that to me is how I would rephrase the question is, wasn't there a simpler way to make the point? And maybe there wasn't.
So I mean, just to put this into a bigger framework, bargaining theory is not a newfangled, novel, innovative theory. It is a tool for illustrating how a merger can create enhanced incentives to foreclose rivals. It's just the delivery vehicle for foreclosure strategy. That's it. It's nothing. It's not separate and apart and new. And I mean, yes, the tool is new. The theory of bargaining itself is newer, but it feeds into how you deliver on a foreclosure strategy. So this opinion, and because of the intense focus on the bargaining theory part of it, is really symptomatic of where antitrust analysis has gone in the last 25 years. It's become very empirically driven. The role of economics is paramount. I would like to see, as I would hope others would like to see, a return to a more balanced approach of law and economics and institutional analysis to make the case for why there's a potential violation of Section 7, Section 2, and even in Section 1 cases. So we're not seeing that. We're seeing an uber focus on economic analysis tools, empirics. Thus, Judge Leon's trip down the road of criticizing evidence and models and input assumptions and all of this kind of thing. And if we want to get decisions that reflect a more balanced view of the different disciplines that go into and support antitrust, we're going to have a very different approach. If the government wants to bring another case just like this, using this strategy, they're going to have better facts and a stronger economic model. If the government wants to bring other vertical merger cases, my suggestion is they go a very different route, which is to create and set the table and create the predicate and the context for why a vertical merger can be harmful to competition and consumers. And that means talking about upstream and downstream markets and market shares and concentration, not because it's a horizontal merger, but because if you have big dominant firms vertically integrating, then yes, you have thus, created at least the first part of a concern about potential anti-competitive effects. And then you start building out the empirics and the modeling and the evidentiary support for that. None of that was present in this opinion. It dove right in to the bargaining model, didn't set the table, didn't create a context for evaluating this. And so we got an opinion that reflected that very sort of surgical, narrow approach. But more than anything else, the consumer should be at the heart of the concern that the government has, right? Or the antitrust laws are about protecting competition and consumers. Judge Leon doesn't think that. He said that he discouraged the government from appealing because it would be unjust to the companies, right? Well, that's an interesting view of the antitrust laws. So there was no mention of the consumer. That needs to be front and center of antitrust enforcement, particularly merger enforcement. And we just didn't get a good flavor of that in this approach.
I think there should be a strong presumption this was the best case they could bring. The government cared. I mean, if you were in the building, they cared. And they hired the best. I mean, it's just, you can't quibble with any of that.
We haven't even mentioned Susan Athey, who was part of the team too.
Absolutely.
So,
So what's fascinating to me, so to focus in on one piece of evidence, I mean, that was to me it always leaps out of my mind. They had to assume what the profit margin that would happen to the merged company from a result. It started off as $6. They, in the initial documents, based on what the research, they changed it to $10 without explanation. And they got the result of harm. And it turns out when they picked at it, if you go back to the original $6 assumption, it's actually prices go down. So there's one of two possibilities about the case. Either they didn't think this through, or they tried their best to defend the number and this is the best they got. I'm inclined to think the latter. I mean, these aren't fools. These are some of the best litigators in the country. It struck me that the plaintiff's case lived and died on these sorts of numbers, and that's the best they could do. And it was contradicted by anecdotal evidence in the plaintiff's side case. Okay, so, and you can't control what the witness is going to say. It'd be inappropriate to try to do that, although you could, a lot of it was lack of depth. Like, I think it'll be bad. Have you run any numbers? No. And I accept the notion that if you just say someone thinks it's bad for me as a bare assertion, that's not analysis. I mean, that's just an opinion that someone can't back up. And you take it for what it's worth, which is, I understand your concern, but without the evidence, you'd be concerned beyond that. The other thing, the reason I think that was the best possible case, the government went to great strength, and the opinion went to great lengths to distinguish between a foreclosure theory and a raising rivals cost theory. And it's fairly clear that they thought that distinction became important to the case because they obviously didn't think they could carry off one of the arguments. And so it's just, it suggests care. Two last thoughts. One is bargaining. Yes, bargaining theory has been around for a little while, but it's only really been prominent in merger analysis in the Comcast, Time Warner, NBCU, and Time Warner cable transactions. Those are both settled. This is the first litigated case that I know of on bargaining theory. And so there's a difference between a settlement and a litigated case that can be very, very different. And so what you start to see is a change in how things are going in terms of, this is the first real acid test of what they're going to do. Last thing, I would not interpret Judge Leon's discouragement of an appeal as being inconsistent with consumer welfare. The conclusion of the merger is that the impact on consumers, the government failed to show that the transaction would harm consumers, which leaves two possibilities. It would be ambiguous or beneficial, neutral or beneficial to consumers. In which case, saying the case was so weak that further delaying the transaction, in one case, if he sees potential consumer benefits, then both sides acknowledge there are efficiencies to this, is actually arguably completely consistent with consumer welfare based on his evaluation of the strength of the case. So by the statement discouraging an appeal by itself does not tell me that he prioritized companies over consumers. It's also consistent with an idea that he looked at the evidence and just thought the better thing would be for the competition consumers would be for the transaction to go through.
If I were the personal trainer for a district judge, I would not include paragraphs telling the parties not to seek a stay, don't do this, don't do this. To me, that reveals a faint uncertainty about whether I made the right call here.
Correct.
If I'd been his coach on this, I would have said, drop the last 2 pages, take them out. They'll figure it out about whether or not. They know They know everybody knows there's a breakup fee, everybody knows there's a deadline. And by the way, the deadlines do not shape our decision making here on this court. You picked the deadline. Why are we bound by it? The Department of Justice said, why would you do that? I would hate to regard that as being the action forcing mechanism that told me how I had to decide, when to decide. But I would end it by saying, this is what I find. You guys can figure out the benefits and costs of seeking a stay, seeking an appeal. You're smart enough to do this. This almost reads to me as though, gee, I'm not sure that this will quite hold up, so don't go appeal it this way, don't seek a stay. They'll figure that out. I think it reveals maybe a lack of complete confidence in the results, a faint bit of insecurity.
I thought he was doing DOJ a favor. No, don't
Cover?
waste your time.
I think they could probably get to the same spot, but
Hi, I'm Heather Heimbach from Broadband Census, a newspaper, and so there were a lot of criticisms that the AT&T Time Warner case was brought to attention for being poisoned by politics because of the Trump administration's role in it. Do you think that that is really the case, and do you think that that had any effect on the decision?
I would say there's no evidence in the process that you can point to that indicates that was the case. And it's just, without a smoking gun, it's really hard to make those accusations.
I'll just add that as a former Antitrust Division person, although I have my doubts about at least how this case might have been brought and what I would have liked to have seen from it, there are a lot of extremely competent and dedicated staff people at the Antitrust Division. It's hard to imagine that, for reasons that everyone on the panel I think has alluded to, that they would have gone this far and stuck their necks out this far unless there was a pretty broad consensus that this was a case worth bringing on their views of the merits of the case and how to do it and so on.
The staff who are not political were
Right.
very enthusiastic about this case.
Okay.
Can I give you a couple of reasons to doubt the hypothesis? First, I don't know, because I wasn't in the room. If there were contacts and conversations, they didn't patch me into them, so ultimately I couldn't disprove it. I don't know. The senior people in the front office have good reputations, good careers. I think they'd be very averse about doing something that could endanger that. And I use the participation of the outside experts, especially Carl, especially Susan, as a rough proxy for whether or not something weird was going on in the background, because they took a big step here to put their names on this and to testify. I don't think they would do it if they thought this was tainted and that their names would appear within 5 words in a search that had Trump, political influence, scandal, plus Athey and Shapiro. I don't think you want to be part of that search. So I think their non-participation is a proxy. I will say that it is a bit of a menace for public law enforcement agencies to have powerful political officials talking about what they should do. It diminishes their credibility. And when you go outside of this country, when you have the people in the building across the street at hearings pointing the fingers at enforcement officials saying, you should block this, or this is what you should do, or the President of the United States saying, this is what you should do, and this has happened a lot in our political experience. Do you know how that's perceived outside the country? Badly. Because if you get a result that happens to coincide with the stated preference, the immediate assumption is that you are a puppet of the elected official, and that's why you did it. And when we go out into the world to speak to countries like China, to speak to the other 129 jurisdictions that have competition laws, when you have a sequence of powerful political elected official declaring that you should do X, you happen, for your own good reasons, to do X, the assumption pervasively is that that is a causal connection, and that diminishes the credibility and effectiveness of the U.S. regime. And in jurisdictions that would like to have that kind of direct intervention, the assumption is they do it, everybody does it, we should do it too. It's really damaging, whether it's a congressional committee telling you what you must do in the course of a merger, or the President of the United States saying, I think this should be blocked. There will always hover over the agency the suspicion that you are simply their servant, and that really hurts the effort to build a sense that you are doing good analysis on the merits.
Well, it also any political interference deprives any participant in the process of due process. So, any market participant, whether they be a customer, a consumer, a company, a distributor, everybody should get a fair hearing under due process. And when you have political interference with that, you are depriving any participant, any stakeholder of due process. And that really sort of cuts to the core of our legal system in this country. That's why it's so abhorrent for something like that to happen. And I think heads of agencies need to make it very, very clear that that they are independent, that they will conduct their investigations independently and thoroughly, and will not entertain or be subject to any pressure, any political pressure.
I'll give you a more distant example. 20 years ago, when Boeing bought McDonnell Douglas, the FTC is examining the transaction. Al Gore goes to Boeing's main production facility in Everett, Washington, in a pep rally-like environment, and tells them, this is an American transaction, it's good for America, and if the Europeans put their hands on it, there will be, his words, a trade war. 3 weeks later, the FTC clears it without a scratch. When you go to Europe, it's hard to persuade a lot of policymakers that that wasn't fixed. I don't think it was remotely. But again, to have that sequence of an elected official going loud about what you should do, and then you take a decision that is consistent with the stated preferences, not caused by it, but consistent with it, it undermines the sense that what's going on at 10th and Constitution and 6th in Pennsylvania is principled analysis. It's really damaging.
And by the way, the one channel where we might see more of this is through CFIUS reviews, right? Where the CFIUS Review Committee can essentially independently nix a transaction if it has implications for national security, whether it's cell towers or siting facilities close to naval stations or anything.
Vanilla
like
yogurt.
The use of chips in weaponry, for example. So I would keep an eye on CFIUS, because that is a big gaping hole potentially for the channeling of political pressure to prejudge certain types of transactions.
So I really agree with Diana and Bill. Just a thought. I know, tell me when we move on, but I do have to admit, as a law professor, lawyers have gotten a pretty rough ride in the last decade or so. I've never been prouder of the law, in terms of standing up to things. And it's, you hear this. I talk to foreign judges, I've been lucky enough, and one of the questions they ask each other is, what do you do when the call comes?
Yep.
And the American judges says, there is no call from political leaders. Okay, you're more sophisticated than that. When they wink and they nod and, the code, how do you deal with that? And it's really a terrifying question. And when you ask them, I was in a conversation where a judge asked another one, what do you think the most important Supreme Court decision was? And the US judges said Brown v. Board or all the traditional things. And the judges from this country, I won't tell you where they were very disappointed. I said, why? And he said, we think the most important decision was the Nixon-Watergate tapes decision. Because the courts looked at a national leader who didn't want to do something, and they made him do it. And that was the rule of law to them. And I think that's something that we have to preserve, both at the agency level, but even more importantly at the judicial level.
So we may have time for these two questions, which will be the last ones.
Merrill, Duke University. A merger outcome the same week, I think, was Bayer and Monsanto via Antitrust Division decision, which had a structural remedy involving intellectual property and R&D assets. And my question is, did in that case, or do antitrust authorities in other cases have a good basis for anticipating or what the innovation consequences of moving those assets around?
Well, I'll respond to that. AAI wrote 2 letters to the DOJ encouraging them vigorously to block that merger as being too big to fix. And they did not. They reached a historic settlement, apparently, that reportedly. And I think the thing to focus on there is that, that's all great, biggest historical divestiture remedy ever taken by the US government or whatever the comparison was. That remedy carries an enormous execution risk. So not only do you have 2 enormous companies that are engaged at all levels, trade, seeds, and chemicals, attempting to combine their companies post-merger, but at the same time they are attempting to spin off assets to a very small competitor, BASF, which will now have to step in, hit the ground running, replace the competition lost by the merger for the remedy to be fully effective. And that's a very, very tall order. That's execution risk on both sides of that transaction, for Monsanto Bayer and also for BASF. And the test of a remedy is whether it fully restores competition. And that doesn't mean, oh, well, here comes the competition once we get all these assets sorted out and figure out how to operate them, because we've never operated in these markets before. It has to happen instantaneously. It has to literally be a full replacement of the competition lost by the merger. So huge execution risk on that. And we were very public about saying that. And that consent order actually contains provisions that are sort of new and interesting, like BASF can come back post-merger and say, well, we need more assets. We have to be able to identify more assets because it's not enough, or it doesn't give us the capability to fully restore competition to be a viable competitor. That's an interesting, weirdly hybrid type of
Structure and behavior,
of remedy.
yeah.
It does. It
Yeah.
has structural and behavioral characteristics, requires monitoring, oversight, compliance, enforcement, all these things. So we'll be keeping an eye on that one and see how well that one goes down, and whether that is a successful execution of a mammoth remedy for a very, very large and anti-competitive merger.
John, last question.
John Mayo, Georgetown University. Thank you. Bill, this goes back to you volunteering to be a personal trainer. You volunteered to be a personal trainer for a judge. I might want to talk to you about being my personal trainer later, but if you were
My obviously great physical shape is compelling here.
If you're suppose
My
now
doctor asked me recently, what was your graduation from college weight? And I said that was a hateful question.
So let me ask the whole panel, just if you were going to be a personal trainer, not for the judge, but for the DOJ. What I thought I heard was a pretty good consensus about this being cabined off decision, that it was very fact-based, that didn't really necessarily convey a lot of precedent for future cases. So if you're going back over to the DOJ and you say, okay, what are you want to bring cases, what are you going to do differently? And what I heard you say, I think, was number one, bring better facts. Number two, I heard bring old Litany of the Saints law. I heard bring different theory to the case, or I heard bring the same theory but dress it up better. And I don't know if it's an all of the above approach or if you were going to lead with one of those. What's your first best personal training advice for the folks over at DOJ moving forward?
First, to do the careful reconstruction of what went wrong. That is to take the judge's opinion on its own terms and ask, did we not marshal our evidence as well as we could? Was there some lapse in forensic skill, in presentation? Did we go about this as well as we could have? How do we address taking on his own terms what he had in mind? So step one the accident reconstruction, where you put things together and you ask what went wrong in order to do it better the next time. Step 2, I would be coming from that, I'd start thinking about, well, what kind of facts would we have to assemble to be persuasive the next time, realizing that if he really doesn't like it, there are no facts on earth that will help. But assume that's not the case, that it's not a cynical exercise. Would have worked in this case, so better facts. Probably not to go back to the litany of the saints that I had in mind from the past, the mothball fleet of decisions. But to think I'm going to find another good one. I'm certainly not going to take on the news accounts that say that this is humiliation, this is a devastating defeat, any more than at the beginning of a sports season losing the first match would say I better take the rest of the year off, which I'm afraid there was a bit too much caution after Oracle. So I'd go, what went wrong? Look for better facts to respond to that. Think about the presentation in a different way. Look for the next one, and certainly not be afraid to play again.
3 steps. First, explain why one side or the other in a pure vertical merger. Explain why one side or the other has got market power. Step 1. 2, explain why they can't exercise that market power already through some sort of thing. And then 3, what it is about vertical integration that allows them to exercise that market power that they couldn't have exercised already. And probably 4 is what facts you need to show along those lines. I think if you could do those things, you'll have a pretty persuasive case. Whether this ever would have fit that mold, I don't really know.
To pick up on what Tim said, that's one thing we haven't talked about, which is a critical part of this case, which is, mergers are not designed to make markets competitive. They're designed to keep them from getting worse. So the answer is, if this must have programming, it must have programming after the merger or before the merger, whether you block it or not. If there's the unilateral theories are such that it's really, the question is, will the merger make things worse? And that is a thread that came out very strongly in this opinion, based on arguments that in my mind the DOJ probably shouldn't have made. Because they were not making merger-specific arguments. They're saying, oh, this market's structured badly, but this merger does not make those structural conditions worse. To the extent to which the DOJ made those arguments, they should rethink them. Now, they might have strategically made them as an invitation to a court to go beyond that, which would be a difficult argument to make for a lot of reasons. But I do think that there were arguments that they made that they might want to go back to the drawing board and really focus on merger-specific harms as opposed to market defects that would pre-exist in the merger and would not be made worse by the merger.
Okay, well, join me in thanking the panel. I thought this was a great discussion.